Show do not necessarily reflect the views and opinions of News Talk 1450 WOL, Radio 1 Incorporated, or their management.
Law Talk with Ethel Mitchell is sponsored by Equity Resource, a development, construction, and investment firm that is transforming properties throughout the Washington, D.C. metropolitan area. Our mission is to develop properties at a high level of value, a low risk of investment, while providing impeccable service to our customers. When you're ready to sell, renovate, or invest in a property, choose Equity Resource. Call us today at 202-621-6632 or visit our website, equityresource.net.
Good morning and welcome to Law Talk with Ethel Mitchell. Now for today's show, here's attorney Ethel Mitchell.
Welcome. Welcome. I'm your host, attorney Ethel Mitchell. Welcome to all who are listening live throughout the world on Radio 1 1450 AM, WOLDCnews.com, and LawTalkWithEthelMitchell.com. We have a great program planned for you today. We're going to discuss copyright recapture and what authors, artists, songwriters need to know. So listen up and learn about information that can really protect and benefit you and your loved ones. This program is also brought to you by my law office, Wills and Trust, LLC, where I prepare wills, trust, power of attorneys, advanced medical directives. So if you or someone you know needs a will, a trust, or assistance administering an estate, call me at 202-772-1988. That's 202-772-1988. Each week you hear me say law is powerful. It can help you or it can hurt you. It impacts everything you do. What you don't know can hurt you, but what you do know can empower you. And this program, particularly today, and the people I have here in the studio, is really geared toward empowering a group of people who are so creative and have not been empowered over the years. So each week, Law Talk with Ethel Mitchell brings you lawyers and professionals to share their knowledge and expertise. But remember, what you hear on the program is for information purposes only. No attorney-client relationship is established by anything said on this program. Each person's circumstances are different, and you must seek individual counsel for any situation for which you need legal advice. All of our programs are archived on my website, LawTalkWithEthelMitchell.com. So if you missed a program, go there. Or if you want to hear this program again, go there. And the programs are posted by my webmaster, Earl Hooks, within about a week at the most of their airing. My executive producer, Stacy Royster, and radio engineer, Darrell Farley, are ready to receive your calls. So call in with your questions. Join the conversation at 1-800-450-7876. That's 1-800-450-7876. Let's get started. Copyright. That's what we're going to talk about today. In 1976, the Copyright Act was amended to allow authors, which includes recording artists and songwriters, who created or transferred creative works beginning in January of 1978, to terminate the transfer of ownership to record companies and music publishers and recapture the ownership of their copyrights. These copyright recapture rights could create a paradigm shift for the music industry by transferring the ownership of creative works back to the artists, but not if artists are not aware of their recapture rights and they exercise them. This is something you've got to do something about. The copyright recapture rights are strictly enforced and will expire for works created in 1978 at the end of this year. Artists and songwriters need to be aware of their rights and seek legal assistance as soon as possible to exercise recapture rights. Attorney Lita Rosario, a nationally recognized entertainment attorney and artist advocate, and Latif Imtima, Esquire, professor at Howard University School of Law and director of the Institute for Intellectual Property and Social Justice, are our guests today to discuss this very important matter. Let me tell you a little about them. Attorney Lita Rosario is the principal of WYZ Girl Entertainment Consulting, a boutique entertainment and intellectual property law and consulting firm in Washington, D.C. She attended Howard University School of Communications, where she graduated cum laude. Attorney Rosario also attended the Howard University School of Law, where she earned her Juris Doctorate degree in 1986, graduating in the top 10% of her class. She is admitted to the state bars in New York, Massachusetts, and the District of Columbia, the federal court bars for the Southern District of New York, the District Court for the District of Columbia, and most recently the Supreme Court. She was elected as chair of the D.C. Bar's Arts, Entertainment, Media, Sports Law section, serving from 2012 to 2013. Attorney Rosario also serves on the Grammy Board of Governors, the Black Entertainment and Sports Lawyers Association Board, and the Board of Directors for the Hip Hop Caucus Education Fund. Attorney Rosario was a co-founder and owner of University Music Entertainment that produced multi-platinum recording artist Drew Hill, Mia, and ultimately
Cisco,
and thank
Amaya.
you.
Yeah.
Amaya, excuse me. You can tell I'm old. I'm sorry, okay? She's also responsible for getting Missy Elliott her copyrights back. Crystal Waters, Tank, and Robin. Attorney Rosario's experience includes drafting and negotiation of entertainment-related agreements with Warner Music Group, Atlantic Recording Corporation, BMG, RCA, Sony Music, Universal Music Group, Elektra Entertainment Group, DreamWorks, Disney, UPN, TV One, BET, Viacom, MTV, Discovery Channel, E-Network, Fuse, and Universal Pictures. In addition, she has negotiated major advertising and endorsement deals with Adidas Entertainment, Mac Makeup, Doritos, Yahoo Pepsi, Lincoln Mercury, Mitsubishi Miller Brewing Company, and Bermuda Tourism. You're a bad girl.
Thank you.
Oh, she's really, really quite accomplished in this. She's represented clients in songwriter and author disputes for mega hit records as Who Let the Dogs Out, Blame It on the Alcohol, Planet Rock and Thong Song, securing ownership rights for her clients in all cases. She's currently representing members of Parliament Funkadelics, including Gary Scheider, Diaper Man, okay, and George Clinton, in matters to regain ownership of their catalog, including the iconic hit records Atomic Dog and One Nation Under a Groove, and the estate of a founder of KC and the Sunshine Band in Florida. Attorney Rosario has lobbied Congress on artist rights issues and is an outspoken advocate for artist rights. Okay. Professor Intima?
Yes.
Is a professor of law at the Howard University School of Law. After graduating with honors from Amherst College, Professor Intima received his JD degree from Harvard Law School, where he was the co-founder and later editor-in-chief of the Harvard Black Letter Journal. He is admitted to the New York and Pennsylvania bars and has practiced intellectual property, bankruptcy, and commercial law, including a decade in private practice with the international law firm of Couder Brothers. Currently a member of the Advisory Council for the United States Court of Federal Claims, Professor Intima has held the post of Distinguished Libra Visiting Scholar in Residence at the University of Maine School of Law, is past president of the Giles S. Rich End of Court for the United States Court of Appeals for the Federal Circuit, and was a member of the founding editorial board for the American Bar Association's Intellectual Property Pyrrhical Landslide. Professor Intima is the founder and director of the Institute for Intellectual Property and Social Justice, an accredited non-governmental organization member of the World Intellectual Property Organization. Welcome to both of you.
Thank you.
I am very pleased to have both of you here to educate and inform and empower my listeners. Lita, let's start with you. Okay. Explain to us, and I really want everybody out there who is an artist, a songwriter, a musician, a author, or the family of these wonderful creative people to listen carefully to what you both have to say. So talk to us first about what is copyright recapture, please.
Well, Congress, in its wisdom, recognized that early on in the careers of recording artists, songwriters, producers, musicians, and even book authors and fine artists and others, that they enter into agreements that don't properly reflect what the value of their intellectual property rights, in this case their copyrights, are going to be later on down the line. And there were some provisions in the 1909 Copyright Act that allowed for what's called copyright renewal, but because of some court decisions or interpretations of that right pretty much has been usurped through contracts. And so Congress enacted Section 203 of the Copyright Act, of the 1976 Copyright Act, that allows authors, which is, broadly defined, but, with
Includes music.
Includes music, absolutely. But doesn't include television and film as an important point. A lot of people need to know that. Includes, because their works are typically considered works made for hire. But we'll get into that in more detail later. Allows authors to basically terminate a grant, meaning a contract that they entered into that transferred the ownership of their copyrights, and to recapture ownership of those copyrights.
That's huge.
It is very huge. It's very big. And this right becomes mature basically 35 years after the date of the transfer or creation of the work, depending upon the circumstances.
Okay.
And if the work was created after January 1, 1978. So the transfer could have been earlier than that, but if the work is created after that date, then it falls into the guidelines of Section 203.
Okay. So let me just to clarify, what happens to works before 1978?
Works before 1978, depending upon the type of work. It's a little more complicated. But there is a 28-year renewal term, initial renewal term, that's been extended a few times by the Copyright Act. So it's actually now a bit longer. But I won't get into the details of that. But originally, 28 years after the grant, you were able to renew, and those renewal rights would vest originally in the author. But what has happened is that through court decisions where contracts say, which typically contracts that involve copyright, so we're talking about recording contracts, music publishing contracts, book publishing contracts, distribution agreements for fine artists and other types of contracts like that, will say that the author is transferring their renewal rights. And if the contract says that, the courts have interpreted that to mean that the rights are also transferred. However, if the author has passed away in that first 28-year term, those rights do automatically vest in the heirs of the author, and that's something else that's
huge.
very, very important to know as well.
Repeat that, please.
If the author dies within the first 28 years of their term of copyright, the first term, then the heirs are automatically vested with the termination rights with the renewal rights.
That's huge.
After that initial 28-year period.
Okay, so I hope my audience is listening to that.
And
if you are a family member of a musician, an author, a fine artist who has died, you may still have certain rights that you can exercise.
Exactly, and that's regardless of what the contract says.
Oh, that's great.
Now, as an interesting point on that, I have clients now who some of you may remember out there, the Sly, Slick, and Wicked, whose song Show Enough was sampled by Justin Timberlake in his very hit song Suit and Tie. And that's the circumstance that we have now with them, that their rights, their renewal rights have vested because the contract didn't include
the renewal rights.
Excellent. So their rights have vested. So that's a situation now. Still, legal assistance is needed, however, because the record companies are not backing off that. So we're actually in a somewhat of a battle now with the record labels, but we feel very confident that we're going to prevail.
Excellent, excellent. We have to go to a break, but when we come back, I'm going to give you Attorney Rosario's phone number where you can reach her, and we're going to hear from Professor Mtima as well. We'll be right back.
1450 WOL. Where information is power.
Do you own a new or used Mercedes-Benz and are looking for a place?
Welcome, NBA fans. Tonight's NBA
Man, nothing beats seeing an NBA game in person. Hey, buddy, thanks again.
Do you own a new or used Mercedes-Benz and are looking for a place that specializes in servicing luxury cars? Magic Benz Services USA, located at 4716 Baltimore Avenue, Hyattsville, Maryland, is the place. They are the premier specialists with up to 40% off dealer prices and 100% satisfaction guarantee, offering professional services to keep your Mercedes running, like transmission services, brake services, complete engine services, tire replacement, balance and rotation, engine cooling system flush, battery and charging system check or replacement, fuel injection services, wheel alignment, used car pre-purchase inspection, and much, much more. So call for your appointment today, 301-985-2676. Or go to magicbinservice.com, and now offering law enforcement, military, and government discount. So call 301-985-2676.
I'm Lex Friedman. I run my own business, so I know from experience, hiring new employees can be tough. Posting your job in one place isn't enough to find quality candidates. If you want to find the perfect hire, you need to post your job on all the top job sites. And now you can. With ZipRecruiter.com, you can post your job to 50-plus job sites, including social networks like Facebook and Twitter, all with a single click. Find candidates in any industry nationwide. Just post once and watch your qualified candidates roll in to ZipRecruiter's easy-to-use interface. And with ZipRecruiter's premium traffic boost, you can get up to 3 times more candidates. Quickly screen applicants, rate them, and hire the right person fast. Find out why ZipRecruiter has been used by over 200,000 businesses. Right now, our listeners can try ZipRecruiter for free. Plus, get 30% off your first traffic boost by going to ZipRecruiter.com/talkradio. That's ZipRecruiter.com/talkradio. One more time. To try it for free, go to ZipRecruiter.com/talkradio.
News Talk 1450 WOL AM. Where information is power.
Yeah, thank you. Welcome back. Welcome back. You're listening to Law Talk with Ethel Mitchell. We have as our guest today Attorney Lita Rosario and Professor Mtima. We're talking about copyright and authors' rights and photographers' rights.
Yes,
also,
photographers.
That came up during the break. Let me give you the phone number in case you want to call. Please call in. We welcome your questions. 1-800-450-7876. 1-800-450-7876. Attorney Rosario, continue telling us about recapture rights.
Right. So getting back to for the issues for works created before January 1, 1978, the basically the renewal right ends in 56 years.
Okay.
So for those works, it takes a bit longer. But for works that were either created or the rights were transferred after January 1, 1978, it's basically a 35-year period that you have to wait.
Okay.
And that 35-year period, there's a little extra 5-year window that gets tacked on the end of it for you to exercise your rights. But the Copyright Act has some very strict statutory requirements that the current owner of the rights has to have at least a minimum of 2 years notice before your termination right can be effective. So you have to send a notice to the current transferee. The way the statute is drafted, it doesn't matter if the original owner transferred the rights 6 or 7 times, and that's important because a lot of people think, well, the original person I signed with doesn't own it anymore. Now Universal owns it, or now Rhino owns it, or someone else. It doesn't matter who the owner is. The notice has to go to the current owner, and it has to be served by certified mail, and you have to have proof of receipt, and then you have to record those documents, a copy of the termination and the proof that it was properly served on the current transferee with the Copyright Office.
Okay.
And you have to make that filing before the termination date. So
Okay.
basically you have a 2-year time period, but you've got to get it in before that 2-year date.
Okay. You are going to, if you want to contact Attorney Rosario, her phone number is 202-628-1092, 202-628-1092. Her website is www.wyzgirl.com.
Right, and can I just give it's best to email, and the email is information spelled out completely at wyzgirl.com. That's
Okay.
a good way to send your questions in and get a response back in a timely manner.
Okay, very good, very good. We have a call from Cynthia in North Carolina. Cynthia, hello?
Hi, how you doing?
I'm fine, thank you. How can we help you?
I'm not for sure if the attorneys will cover this or if it has anything to do with the subject. My first question is, what about these television commercials using the artist's songs in their advertisement? Because I know there's a lot of commercials are using a lot of the music from the artist.
Right.
And my second question is, what about these authors that write these biographies on other people? Now, do they have a right to do they have to have some kind of contract or legal agreement where they can be able to write biographies on someone? For example, if somebody's famous, do they have a legal right to do that?
That's a good question. Lita? Professor?
Well, I'll take the first question, and I'll leave the second one to Lateef. Certainly when music is used in TV commercials, that's income. Those commercials are paying. In general, advertisers are going to pay for the use of music. The question is who's getting the money, and that's why these rights are so important, because if you recapture your rights, you're getting the money. And typically when music is used in an advertisement, if it's a television advertisement and it's national, that could be a 6-figure license. That could be $100,000 use for one time.
That's huge.
Certainly like a $20 or $15 or $20,000 use. So that's a big supplement to someone's income, and certainly for a family, for an estate, that's a significant asset. That's one type of 4 ways that basically you make money from your copyrights.
Okay.
And we could talk a little bit more about that later, but it is very important, and that's the money that you would be able to collect. And in addition for it, actually, when the commercials run, you get what's called performance income, which is another type of income. So that's the rights you'd be getting back.
That's great. Very good. Professor Mtifa, can you talk about the right to do a biography? I thought that was an interesting question.
Yeah, no, that's a very good question. I'm glad you asked it. It involves a kind of intellectual property right that many people are unaware of. It's called the right of publicity. And basically what the right of publicity provides for, and even some people who are aware of it think that it is a right that belongs only to famous people and celebrities, but it's not true. We all have the right of publicity. And basically what the right of publicity says is that you can prevent other people from utilizing your image, your name, your persona, because sometimes it's not exactly your face or your name, it's aspects about you that from those aspects people can tell that you're the person that is the subject of the work. And you can prevent other people from utilizing your persona, sort of as the collective way to say it, for commercial purposes. Right? So if someone wants to use your face or your persona in an advertisement or a commercial or things of that nature, they have to get your permission. Now, when it comes to something like a biography, that implicates the right of First Amendment. And see, here's basically what the problem is. On the one hand, we all have this right of publicity to protect us from other people exploiting who we are in a commercial context. On the other hand, in the United States, we have a great tradition of First Amendment. And so if I want to do a news article or write a book or tell a story that involves real life people, Well, the First Amendment is going to allow me to do that. And we don't want the right of publicity to basically allow individuals to control what happens in the news, for example, or what kind of information gets out to the public. Because obviously, if I can prevent you from talking about me, and I was involved in some newsworthy event, or I'm involved in some great historical, development, well, then people can't tell the story. Right? Mm-hmm. So what happens is that you end up, what the courts do is when this issue comes up, you have to balance the two. Mm-hmm. And specifically in the case of biographies, generally speaking, the way we balance that out is that if I'm going to write a biography about factual events, and it happens to include you, if I don't have your permission, generally what we do is we indicate that that is what we call an unauthorized biography. Mm-hmm. So this way it's made clear that I am reporting facts, but you are not endorsing that. Right? Mm-hmm. Mm-hmm. Generally speaking, what publishers and writers do when they're going to do a major work like a biography or a biographical movie, usually the compromise that to work around that is oftentimes they will hire the individual as a consultant. Right, so is that we don't end up with these types of issues because of course. I'm sorry. Go ahead. What were you going to ask?
I don't mean to interrupt you. Mm-hmm. So in an unauthorized biography, they can still legally write it, even though the person didn't give them permission to do that. Can they still get some type of compensation off the unauthorized and the authorized biographies?
Well, see, that's the reason why we allow under the First Amendment the unauthorized biography, because basically, for example, let's say you wanted to write a story about something that happened in your neighborhood last week, something that was true, right? And it involved some of your neighbors. If they could use their right of publicity to say, well, you can't include my name unless you pay me, then it would mean that you couldn't tell a truthful story, right? But the way that we make certain that people understand that when you tell that story, that the individuals who are in that story, that they're not endorsing it. They're not saying that, yes, your story is right, your story is accurate. They're not supporting it in any way, shape, or form. That's when you make it clear that this is an unauthorized biography, right? Now, of course, that could have an impact on the market for the work, right? I mean, if you're going to go and see a movie about a famous person, if people understand that that person didn't authorize it, that person is not saying that what is said in the story is true or accurate, well, then some people are going to say, well, I don't really want to go to that movie. Or I don't really want to buy that book. And so that's where the right of publicity can be very important, to give you some leverage, even though it bucks up against the First Amendment.
And if it's unauthorized, I think your question, Cynthia, is if it's unauthorized, then the person who it's about doesn't get any money from it.
That's right.
Okay. But if it's authorized, you might get some money from it.
Right.
Okay.
So in the unauthorized book, even if they put in facts that's not even true, so can that person sue their author for that?
Yeah. See, now that's a different issue. That's a different area of the law. That comes under the law of what we call defamation, for example. So anytime, whether it's a book or a newspaper, what have you, and this is not an intellectual property issue, if somebody says something about you that is not true, okay, even if it's not in the book, right? I mean, you can go after them, you can pursue them legally, and your instincts are very right? Because when you think about it, if I write an unauthorized biography and you don't like what I say, then what you can do is maybe you can't stop me from publishing it because I have my First Amendment right to discuss true facts, but then you can read it very carefully, and then you can point out some places in which you say, wait a minute, what you said is not right, and I think it might be defamatory, and then you can come at me that way. See, so that's another reason why if I'm going to do a work, it kind of makes sense that I get your okay and get you involved, and in turn give you some compensation for that.
Yeah. Very good question, Cynthia.
Okay.
Thank you.
Thank you for taking my call.
Thank you very much. Of course. Let's go back, Lita, to helping authors, photographers, and musicians get some of this money that's being made from their works.
Yes.
Tell us a little bit more about that, and then I want to go to the professor, and maybe you can tell us about some cases where people have actually sued and been able to do that. You know.
It's really important that you have a lawyer to help you with this process, because the technical requirements of the Copyright Act really have to be complied with, or else you're not going to have any success. Another important aspect of this is that if the agreement was executed by more than one author or creator of the work, then a majority of those creators have to sign off. So let's say hypothetically the Gap Band. Right? So the majority of the members of the band would have to sign off.
And if they're dead?
The termination. And if they're dead, a majority of their heirs would have to sign off.
Okay.
So that's one of the complicated parts of this, especially if some of the co-authors have died. However, if they've signed different agreements, let's go to the recording industry. It's very common in the recording industry that there will be one recording agreement, and if the group has more than one member, that all of them have signed the same agreement. But on the music publishing side, which is the side of the business that deals with songwriters and composers of music, typically their agreements are only signed by one author. So you might have and I have no idea, let's just say a hypothetical band from the 1980s, early 1980s, they all signed the same recording agreement, but then they each separately, individually signed a music publishing agreement. Well, they would have to have majority of them to terminate the recording agreement, which has some complications as well, which I'll get into in a minute. But with regard to the music publishing agreements, which is where their songs are being held, or their copyrights to their songs, they can terminate those by themselves if they're the only ones who have signed.
That's excellent
So that's
information.
important to know. The other technical part of this that makes it complicated, particularly for recording artists, is that the statute provides that if the works that you're attempting to terminate or recapture are works made for hire, then they're not subject to this recapture. And that's going to be a big issue for recording artists, an issue that's going to end up before the courts. On the music publishing side, it's a much cleaner situation because typically music publishing agreements don't transfer rights as works made for hire. So the real question is going to be, are recording artists employees of their record companies? And in the overwhelming majority of the cases, the answer to that question is going to be no. Right?
No.
Because for a variety of reasons, the Supreme Court in a case called Reed versus the Community for Creative Nonviolence that actually came out of the D.C. area, the court ruled that regardless of whether or not a contract says, and this is a Supreme Court decision, whether or not a contract says that a work is a work made for hire, it has to in fact be a work made for hire, meaning there had to in fact be an employer-employee relationship between the parties in order for it to be.
Wow.
There are other ways that you can possibly create a work made for hire, but sticking to the recording contract scenario, the analysis is going to go down to indicia of employment. So were you paid a regular salary? Did they deduct taxes and benefits out of your paycheck? Did you have to come to a regular place of business? And a particularly troubling problem for the record companies is going to be that recording contracts typically also have some boilerplate language that says that the artist acknowledges that they're not an employee.
Excellent.
And that they're an independent contractor. But the record companies have traditionally filed these works. When you make a copyright registration, you have to indicate in the registration that the work is a work made for hire. And the record companies have traditionally done that. There are a lot of situations, and one more that I'll give you quickly is Africa Bambaataa and Soul Sonic Force. I did terminations for them. The interesting thing about their contract is that the actual contract itself has no work for hire language in it.
Wow.
And Tommy Boy Records in general, this was a form contract that they were using. So if you were signed to Tommy Boy, there's a good chance that there's no work for hire language in your recording contract at all.
Which means you can recapture your
Exactly,
rights.
which means you'll be able to recapture. Now, they may dispute it. It may end up in some type of a court battle, but I feel that under those facts, you're very likely to succeed.
It's worth it to try it.
Another problem that record companies will have is that a lot of times the works were already created before the artist signed their recording contract. They recorded them themselves and then shopped the deal and went and got a deal, and the copyrights were already in existence. So it's a legal impossibility for them to be a work made for hire in that context. So
that is great information. You're listening to attorney Lita Rosario. Again, her website is wyzgirl.com. You can reach her at information@wyzgirl.com. Her phone number is 202-628-1092. I'd like to hear from Professor Ntima. Tell us a little bit about, maybe in doing research, I noticed that you are very familiar with the, was it Mixed Chicks case? Tell us a little bit about that. Seems like a good example, maybe, or if you have another one, of the use of, or the misuse, taking somebody's creation that ended up, where Sally Beauty had to pay $8 million.
Yes, exactly.
Tell us about that, please.
Yeah. Well, all of these things really go to the central theme of what I've called for the past, dozen years or so, the theory and concept of intellectual property, social justice. And, when I've been using that phrase, and it actually is the title of my book, Intellectual Property, Entrepreneurship, and Social Justice, the first thing that happens is that for many rights holders or people who are sympathetic to rights holders, they think that what we're saying is that we want to undo the copyright system, we want to undo the patent system, undo the trademark system, and make certain that everybody can get your copyrighted material for free, and nobody has to pay, so that poor people can get books, et cetera, and get medicine, what have you. And that's actually the opposite of what we're saying, because there are issues in which intellectual property rights do prevent poor people and people in developing nations from having access to things that are protected by intellectual property, from having access to information and knowledge or medicines and health. There are those sort of situations, and that is an aspect of intellectual property social justice. But another aspect is what we've been talking about today. I mean, the fact of the matter is that particularly in marginalized communities, particularly in communities in the developing world, oftentimes individuals, they don't know what they have. They don't know what they have is a form of property. They don't know what intellectual property is. They don't know the steps that they can take to protect it. And they don't understand the value of it or how it is commercialized. And so they oftentimes end up in these types of agreements in which they really aren't getting a fair price for what they have developed. And that's why you have these situations in which the record company might make millions, and then you hear about the artist years later, and this person is living on welfare. Right. And so that's one of the reasons why this recapture is so important.
It's so important.
There are other aspects, though, to intellectual property social justice, and the Mixed Chicks case that you referenced is an excellent example. In that situation, there were women who self-described themselves as women of mixed descent. They came to realize that when it came to hair products, that there often were not hair products that could accommodate their individual hair textures, right? And we all know in our community, hair is very important, right? So what they did is that they developed a line of hair care products to address that issue. And it was so successful that, as you mentioned, Sally Beauty, one of the largest hair care product distributors and retailers, approached them and said, listen, we'd like to buy your brand. We'd like to start to distribute your product, and we'll just absorb you. And the founders said, no, thank you very much. We're doing very well on our own. Well, lo and behold, very soon after, customers began to notice a new product called mixed silk. And Mixed Silk was very much like the Mixed Chicks brand. It was very similar in its packaging. It was very similar in its texture. It was so close, in fact, that there were customers of Mixed Chicks who got in touch with them and said, "Hey, I saw your new, cheaper line, right? And this is great. We're going to start buying this instead." So the founders of Mixed Chicks started a litigation, and this was trademark litigation, right? Because basically, this other line of product, it was so close in appearance in terms of its packaging and texture and items that it confused the public. And you see, that's another aspect of intellectual property social justice. Trademark exists to protect distributors, people who develop products, but it also exists to protect the public so they're not confused and that they buy something that is different than what they thought. Ultimately, this was one of the rare situations in which the folks from the marginalized community won, and they won a multi-million-dollar verdict.
Yeah, I saw
and it
that.
was because they had the intellectual property foundation, the intellectual property knowledge that they knew to go out and to get a trademark to protect their product.
So they had the trademark before it went on the market.
Exactly.
Very important.
Exactly.
Very important.
Exactly.
So do both of you recommend, okay, let's go, we've been talking about the past, when you've already done something. For members of the audience who are listening right now, and they are creating right now, they're creating software, they're creating music, they're writing, they're drawing, and so forth. What do you recommend that they do to protect their creations? What do you, Lita, you want to go first, and then the professor?
Sure.
What do you recommend?
Well, if it's a work that should be copywritten, for sure, they need to make sure they get a copyright registration.
What kind of work is copyrightable?
Okay, so works that are copyrightable are generally original works of authorship that have been fixed in a tangible medium. And that's kind of a very general description of it. I don't know if you want to add anything to that, Lateef.
Well, yeah, I mean, I think basically to sort of restate what you just said in terms of layman's terms, anything that you express, I mean, when you express yourself through words, you express yourself through paint, you express yourself through photography, you express yourself through clay. All of those are copyrightable works, right? And so what Lita basically just explained is that if you have that type of work, okay, it is copyrightable subject matter. Another really important aspect to this is that in order to have your copyright, and this is something really unique about copyright, the minute you create the work, the minute you fix it, the minute you put the words on paper, the minute you put the paint on canvas, the minute you put your dance steps on tape, it is now protected by copyright, right? So in that sense, registration is not necessary, but registration is very useful because, one, it helps you to prove that you did it, right? It is also necessary to have that piece of paper to go into court to bring a lawsuit, right? And because it's so inexpensive to get, $35 for a registration, it's something that you probably want to have, okay, especially if you're creating works and you're sharing them with the public, right? So if you're writing poems and keeping them in your desk drawer at home, well, you might not want to spend the $35. But once you've got like 100 of these poems and you've decided that you're going to go out and do readings at coffee houses and things of that nature, then it makes sense to take that collection, send it into the Copyright Office, pay the $35, and now you're protected.
Right, and if their works have never been published, you just pay the $35. In some instances, it's $45 now. If they have been published, you'll have to pay that amount for each individual work. So you can't kind of file it as a collection.
I see.
But it's very important to get that done. And there's a notion of poor man's copyright, which is this concept that you can put something in an envelope and mail it to yourself, and you've protected.
Is that any good?
It's not any good. The most that can do is prove a date and time when the work was in existence. That's the best that it's really going to do. But of course, if you open the envelope, you've destroyed the concept of proof. And a lot of people don't realize that either. So you can't open the envelopes, right?
Wow.
But more importantly, the better thing to do is really just to go online to copyright.gov. The site is pretty user-friendly. I mean, you have to fiddle through it a bit, but you can get it done. And alternatively, you could hire a lawyer, a paralegal, or someone to do it for you. There are some services on the internet, but you have to be careful that you don't get overcharged. And it's also important for, I'm going to point this out for, and this kind of comes up in the blurred lines issue. We're creating works now in a new way because of digital technology, and just also because of the genre of hip-hop music, things are happening differently, and lyricists are writing lyrics down, and they're keeping notebooks that are kind of akin to a poet's notebook, right? And these kids are doing this, and they're keeping these notebooks. What they don't realize is that if they go in the studio and put those lyrics on a musical track with a producer or with another third party, that they're creating a song. They're considered joint authors at the time that they fix those two things together. And you can't just now walk away from that music and say, I want new and different music, unless you've copywritten your lyrics before you go in the studio. Or you enter into a written agreement with the producer that basically says, we're going to try this out, and we're not agreeing that we're co-authors, right, at this time, unless we decide that we're definitely going to go forward with this particular work. So that's something important for them to know, because that can cause a lot of confusion. In this modern world, you know, people are creating works with digital technology in ways that they've never done before. And so you're composing or you're creating at the same time as the fixation, and you might be creating a joint authorship, and you've got to be aware of the fact that that's happening. So does that mean then if you have music or lyrics and you go into the studio and you lay the track, whatever it is you call it, that the producer now automatically becomes a co-author of that work, because now it's a musical work, right? There's an argument that lyrics themselves are separate, and whether or not they would be given copyright protection as a musical work. Certainly they're entitled to copyright protection, but copyright protection as a musical work is something a little different, because there are some other statutory issues that come up, like compulsory licenses and other things that don't apply to literary works, that it would be if it were just a poem or just lyrics, versus if you're registering the work as a musical work.
I would really recommend that anybody who is considering doing any kind of musical composition in this, or any kind of creation, but especially musical composition, have a consultation with you.
I think that's a very
no. I mean, she didn't tell me to say that either, by the way. But it sounds awfully complicated, and
and I do that frequently, because a lot of developing artists or up and coming artists, they frankly can't afford to pay my legal fees. But what I will do is sit down with them for an hour for a consultation fee, and I'll give them some basics, and I'll show them some basic things that they need to do, that they need to be working on now before they're really ready to incur the cost of legal services.
Right. Let me give you, if my audience may remember, Lita came on and talked about blurred lines a couple of months ago. Yes, this is the same attorney. She's great. Please feel free to call attorney Lita Rosario at wyzgirl.com. Phone number 202-628-1092. That's 202-628-1092. And I'm going to have Stacy put up her information and the information for Professor Mtima and his book on intellectual property, which I thank you is really, I think, something that anybody in this field needs to be able to to learn and know about, because that's how you make your money.
That is.
Yeah.
That's how you make your money off of this.
If we have time, if you have okay,
Yes.
we were talking about how people can better educate themselves. If I could, there are 2 free events that are going to happen this week
please.
where people can go. The first one is actually on Monday afternoon. It's a collaborative event between Disney and Google. It's an event to inspire young girls to learn computer science. Which is covered by copyright. That'll be this Monday from 3 to 4, and it's actually going to be at the Google offices in D.C. And you can just, if there's one place you can Google easily, it's Google. So you can find out where they are. The other one that is more direct to what we've been talking about today is on Tuesday afternoon from 3 to 5, followed by a nice reception. We're going to have a program called Up Next, The Changing Faces of Creativity. This is going to take place at the Museum Night Broadcast Studio. And again, you can just look up museum if you're going to be in the D.C. area and attend that. And individuals on this who have used the intellectual property law to develop their businesses, use the internet to distribute and self-distribute their product, those are the kinds of people who are going to be there speaking. I'm also going to be there, one of the panelists, to basically give all of you people out there who are saying, wow, this is so much stuff, a couple of hours to give you the basics so that when you then next call up Lita and you go to see her, you at least be somewhat intelligible and you can make so much better use of the advice and the consultation that you'll be able to provide.
And what time is that event again?
That event is Tuesday, May 19th. It starts at 3 o'clock. It goes from 3 to 5 for the 2 substantive panels, and then there's going to be a really nice reception afterwards. And all of this will be at the Museum Night Broadcast Studio, which is on Pennsylvania Avenue in Washington, D.C.
And is that open to the public? I mean, do you need to register or anything like that?
You can register if you want to register really for either of these events because they're free and open to the public. You can either send an email to me or you can send an email to Kate Shearing. It's KATESHEERING at google.com. That's Kate Shearing at google.com, and you can register that way. But if that was too quick, you can always send an email to me, and I'll make sure that you get taken care of.
What is your email address? Give that to us, please.
Yes.
And Stacy, would you put that out on Facebook? Thank you.
You can email me at first initial L, last name Matima, MTIMA, at IIP as in Peter, SJ.com. That's the initials for the Institute for Intellectual Property and Social Justice. So
okay, repeat that one more time, please.
It's LMTIMA at IIPSJ.org.
Very good. Very good. As usual, the time goes by so fast. But I want to thank you both for coming. And is there we have a few more minutes. Can you kind of give us a sort of summary of the most important things that you want my audience to take away?
Sure. I think the important thing is that the time clock is basically ticking very quickly.
Okay, but that's only for 1978,
yes,
right?
for 1978.
Okay, but anybody after that.
Right. It's a rolling, the way the Copyright Act works, it's rolling. So then the next group will be works created or rights transferred in 1979 and then 1980. So the 35 years is rolling forward, right?
Okay.
And the little 5 years that attaches on the end, we're at the end of that 5-year period. What we're coming up on is the end of the 2-year notice requirement for the end of the 5-year period for works created in 1978.
Okay.
Or transferred in 78.
So if somebody has what they think are copyright that could be recaptured,
yes,
I would recommend, regardless of when it was,
exactly,
okay, that they get in touch with you and see what can be done, because you're not saying only those works in 1978,
right,
but any kinds of copyrightable works might be available for being recaptured.
Exactly, and you can give the notice as early as 10 years before the termination date. So really we're talking about, we're riding all the way up to 1988 for works created up to 1980, where you can send the notice. And why I would say do that now is just in case one of the other co-authors dies, passes away, and then you've got to find their heirs. It's better to get it done now, get the notice in, and know when your rights are going to be recaptured.
Okay, that sounds good. That sounds very, very good. And Professor, what do you want my audience to take away here?
The thing I would add is that I think it's really very important that, because this is so complicated, that you do reach out to someone like Lita Rosario and have a conversation, because, for example, as she pointed out early on, oftentimes you transfer the right and then these rights change hands, right? So if you wait until the last minute and you send out your notice, you may not find out until it's too late that you've sent the notice to the wrong person, right? Okay.
Mm-hmm.
So there are so many different complexities involved here that overall, both in terms of whether it's copyright recapture or any of the types of intellectual property we're talking about today, I think that you need to develop what I call community intellectual property awareness.
Mm-hmm.
We have so much. We have so much from copyrightable expression, people doing software, people create things every day. People don't realize that, for example, if you're in the hair care business, meaning I don't mean products, meaning, you have hair styling techniques and things of that nature. People come into the salon. You have things that may be protected by trade secret protection, right?
Wow.
Which is free. All right.
Mm-hmm.
And so it is a wide range of things that we just need to come to these types of programs and to seek out people like Attorney Rosario to have some basic understanding. One of the lines in my book is that if you don't understand the value of what you have, someone who does will come along and take it from you.
Oh, yeah.
Yeah. And so this will change that paradigm if we just go out and get that really basic information.
Mm-hmm. I heard a story that one of the original creators of the Internet was a black man. Yes. And they sold to some company, got a couple of million for it, but then that company sold it for billions.
Yes.
Is that a true story?
Yeah, actually, it's one of the opening anecdotes in my book that back in the 1990s, when the Internet was just starting, the way in which you get a presence on the Internet, and what today we call a domain name, this is how you get your web page, your web address. There was one company called Network Solutions that pretty much, something like 90-something% of the domain names, you had to go to that company to get it. And as you pointed out, what most people do not understand was that Network Solutions was started by two African-American men.
I didn't know that.
Right?
I didn't know both of them.
Yeah.
Wow.
And the thing of it is that here it is. So people think that we were behind the times when it comes to digital information. We were there at the beginning. But just as you described, some of the traditional challenges that we have in our community, and I've spoken with Mr. McHenry, who was sort of like the lead developer, and we talk about it a little bit in my book, that one of the challenges that they faced was that here it is, they had this incredibly valuable business, and one of the reasons that they had to sell was because they couldn't get continuous financial investment and backing, not only from the white community, but also from many people in the black community.
Yeah,
right?
People just didn't understand.
Exactly.
How valuable
and this
it
is
was.
Why they ultimately sold it for a couple of million, and 2 or 3 years later, it was resold for something like almost $1 billion. I mean, it's one of those travesties.
Wow. Well, that's a true story. My goodness gracious. Well,
one of the reasons why you should always keep some back end right for a royalty or some contingent compensation if you can.
You never know, right? Well, thank you both. Thank you both very much. And we're going to find a way to continue this conversation. And my listeners, listen in next week. We'll have some more very good information. Thank you both. Stacy is posting their information on our Facebook page, and we will be back next week. Have a good week. Thank you very much.
You've been listening to Law Talk with Ethel Mitchell. Be sure to tune in next Saturday at 9 a.m. for another informative broadcast. To reach Attorney Mitchell, you may do so by calling 202-772-1988. That's 202-772-1988. Or log on to her website, www.lawtalkwithethelmitchell.com.